Let me explain when the chain of causation might be broken by asking this question based on a case example. Will poor medical treatment mean a defendant is not guilty of a one-punch manslaughter charge because of an intervening act? In Latin, a new intervening act is novus actus interveniens. In this example, sometimes the accused might try to argue it wasn't their punch to the victim's head that caused the victim's death, but poor medical treatment, or even the actions of the victim themselves. Anyone but the accused. This issue is important in criminal law and criminal trials up and down the country. If the chain of causation is broken by a new intervening act, legal causation has not been established by the prosecution against the accused, and thus the accused must be found not guilty. But if the chain of causation is not broken, then legal causation has been established by the prosecution against the accused. Then the case moves to the next issue, whether mens rea or guilty mind can be established, and whether there are any defences available, which are for other criminal law classes. But for now, the question which should be asked is this: what is the test the courts asks themselves to determine whether the chain of causation has been broken by a new intervening act? Let's look at possible intervening acts which might break the chain of causation in the following 6 examples: by a victim in escape cases, by a victim in voluntary euthanasia or suicide cases, by a third party like a delayed ambulance to a scene of an incident, by a third party like a police officer in a shootout case, by a doctor's poor medical treatment, and by so-called acts of God. In escape cases, as per the case of R versus Roberts, a victim escaped by jumping out of a moving car as a result of the defendant's unwanted advances in the car. The defendant was found guilty of ABH, actual bodily harm, even though the injuries were caused in part by the victim. The test in that case was whether the victim's actions were reasonably foreseeable. And in recent cases, like the case of Williams and Davies, the test now seems to be whether the victim's actions were a proportionate response to the threat they faced. So a proportionate response by the victim would not break the chain of causation. But sometimes the facts might be different if the actions of the victim are considered daft and not a proportionate response to the threat faced. Now, in voluntary euthanasia and suicide cases, the test is voluntary euthanasia does not necessarily break the chain of causation, and the question was whether it was reasonably foreseeable that the victim would commit voluntary euthanasia and suicide because of their injuries, as per the case of R versus Wallace. In the Wallace case, the victim travelled to another country for voluntary euthanasia or suicide after being acid attacked a couple of years before by the defendant, Wallace. And the question for the court was it reasonably foreseeable that the victim would commit voluntary euthanasia or suicide following an acid attack? That's the question for the jury. In delayed ambulance cases, if an ambulance comes late to a scene of an incident and the victim dies between the culpable act, say the punch, and the consequence, the death of the victim, again, the question is whether the chain of causation has been broken by delayed ambulance. And the test is, was the ambulance driver's actions free, deliberate, and informed? If the ambulance, say, got stuck in traffic, the actions of the ambulance driver would not be free, deliberate, and informed. Then the chain of causation would therefore not be broken, and the accused would still be criminally liable, assuming the mens rea is also met and there are no defences available. But if the ambulance driver decided to go to Miami's for a spicy burger and chips before getting to the scene of the incident and knowing about the incident, the ambulance driver's actions were free, deliberate, and informed, and the chain of causation would potentially be broken, and the accused may be liable for that offence of manslaughter, assuming the mens rea and there are no available defences. When it comes to a police officer shootout case where the defendant who held a hostage was shooting at police officers and the hostage died as a result of a police shot, the test is again whether the actions of the police officer being shot at was free, deliberate, and informed, as per the case of R versus Padgett. Here the courts ruled the actions of the police officer was not free, deliberate, and informed, as the police officer was acting instinctively and in self-defense. Thus, the chain of causation was not broken. When it comes to medical negligence cases, the test to determine whether the chain of causation is broken is found in the case of R versus Cheshire. Now listen carefully to what the judge said in a case in which the jury have to consider whether negligence in the treatment of the injuries inflicted by the defendant was the cause of death. The defendant's acts need not be the sole cause or even the main cause of death, it being sufficient that his acts contributed significantly to that result. Even though negligence in the treatment of the victim was the immediate cause of his death, the jury should not regard it as excluding the responsibility of the defendant. And this is the important part of the judgment. Unless the negligent treatment was so independent of his acts and in itself so potent in causing death that they regard the contribution made by his acts, that is the defendant, as insignificant. In short, poor medical treatment and medical negligence by the doctor has to be extreme to break the chain of causation if the accused is to succeed and escape criminal liability, like the walls of the hospital falling and killing the victim even when the victim was recovering from an accused punch. And finally, when it comes to so-called acts of God, if the intervening action are unforeseeable to the reasonable person and unforeseeable to the accused, then the chain of causation is broken. For example, imagine the accused leaves an injured Steve who is unable to move on a beach at low tide and Steve dies by drowning. The accused will be liable as it is foreseeable the tide will come in. But if the accused leaves an injured Steve who is unable to move in a garden and Steve gets struck by lightning, then the accused will not be liable as the lightning would be unforeseeable. Remember the different tests for different situations as developed by case law and how they apply to a given problem situation, so you can properly advise your client when the chain of causation has been broken or not by a potentially intervening act. Feel free to comment and follow criminal law classes for more.